afternoon, everyone. We are excited for our speaker today at our September Lunch and Learn. We have Talhia Rangel with Advocacy Law. And she's going to talk about estate planning and how the process of arranging and managing an individual's assets and finances can help them in the long run. So I'm going to let her take a few minutes to introduce herself, and then she can share her screen. If you have questions, please put them in the chat and we will try to answer them, and then we'll end with some time for some Q&A.
Hi, good afternoon, everybody, and thank you for being here this afternoon. I hope that wherever you are in Florida, you're having good weather. I'm going to go ahead and start my screen. So hopefully I have access. So as Dina mentioned, my name is Talhia Rangel, and I am the founder and managing attorney of Rangel Advocacy Law. I always start my presentations with sharing this wonderful picture of my family. So I am a big sister of a little girl with Down syndrome. I was a law professor at a law clinic at NSU for about 5 years, where we handled guardian advocacy cases. We did disability-related discrimination. And once my fellowship was over, I kept asking myself, what do I do? I really like this area of the law. It affects me personally as a sister with someone with a disability, and I enjoy educating and empowering parents with information in this area. So that's why I decided to open Rangel Advocacy Law. So we are a small law firm where we do guardianships. We specialize in guardianship alternatives, which include guardian advocacy, powers of attorneys, supported decision-making agreements, and we also do restoration of rights, where a lot of parents did not know at the beginning what guardianship or guardian advocacy was like, and now their children are able to do decisions on their own. So the process where we restore their rights that do not have to involve any court process later on. We also do special needs and estate planning, which is what we're going to focus on today for the presentation. But we also provide services in the denial of services, which mainly includes the I-budget waiver. So if you have applied to APD regarding the I-budget waiver and you have been denied, we also provide legal representation during that process. And then last but not least, disability-related discrimination, whether it is at a public place or at a state or local facility. So those are the variety of services that we provide in our firm. If we don't know the answer to the question, thankfully, we have worked with a lot of community partners where we refer our cases to, especially for the special education area. So the main question is, what is estate planning, right? And estate planning is the advanced planning of the managing and the distribution of someone's assets after they pass, right? So it's how your assets, your income, your home, or any other property or any other personal affairs is going to be managed and distributed. Sometimes it involves a comprehensive overlook of documents that complement one another. And if you are sitting behind the screen now and you're asking, well, who's going to make my decisions when I no longer can? Or who's going to take care of my children now that they are minor? Or if your children have disabilities, who's going to take care of them? And how are my assets going to be managed? How are they going to be distributed? The most common question is, I only own my home. Do I even need to have an estate plan? And the answer is yes. How do I protect my government eligibility or my children's government eligibility, since they are recipients of Medicaid or SSI benefits? And then the last question is, how can I reduce the burden, the stress, the financial responsibility and conflicts for my family. So if you have all of these questions or even one of them, I always recommend to speak to a professional in this area and share your concerns so that they can properly guide you. We have, since we serve the disability community, we have a lot of parents who are in the process of ensuring everything is taken care of, once they pass. So since our specialty is guardianship, guardian advocacy, and other alternatives, we are dealing with a lot of parents who are preparing for that process because their children are entering adulthood. And while guardianship and guardian advocacy and any other alternative is crucial so that you can continue to make decisions for them, us as parents, we are always thinking about our children that sometimes we forget to think about ourselves, right? So you have to start thinking, what can I do to make sure that everything is in place for when I pass and my children don't have to worry about that? So why is estate planning important? And there's many, many reasons, but it ensures that your assets and anything you want to leave behind once you pass go to the people that you love, right? And it's not ultimately decided by Florida. It also minimizes how much taxes and fees the estate pays. It provides financial medical well-being if you are later on unable to make decisions for yourself, which is something that we all will go through, right? We all get older, we all lose somewhat the ability to make informed decisions. So we want to leave that to the people who we trust the most. It also reduces the legal burdens of hiring an attorney when you pass, of the whole probate process. And if you have minor children, if you have children with disabilities, it allows you to name a person who will be a guardian to ensure that your children are taken care of, right? So this is extremely important for those who have minor children or children with disabilities. And if you do have children with disabilities, it protects their eligibility for government benefits so that later on, when they receive those assets that you own when you pass, their SSI or their Medicaid eligibility is not affected whatsoever. So when we have clients come into our office thinking about a will or just a power of attorney or don't know which document is best for them, we tried to explain each of these documents at length, right? Because there are very, very frequent times where we have parents that say, I only want a will, right? And I understand a will is very, very important, but a will is not 100% protection, right? Each of these documents have a different purpose, but they all complement one another. So doing a comprehensive estate plan is crucial in the sense that if you have children with disabilities and you own a home, you have retirement accounts, a trust may be more appropriate. But you also need a will for when you pass. And we're going to dive in depth into each of these legal documents so that you can be informed and empowered in regards to which one is more applicable to you. So trusts. A trust is a legal document where you, as the settler, you are naming another person who later on is going to be the trustee to hold, to manage, and to protect any money or property you leave behind for your beneficiaries. There are a ton of trusts. There are pet trusts, there are special needs trusts, there are revocable trusts, irrevocable trusts, pooled special needs trusts. So I'm sure you've heard the word trust be used in very different formats. The one that we typically do a lot at our firm is the revocable living trusts. And these trusts are created during a person's lifetime, right? These are flexible. You retained the power to amend, to change it, to revoke it during your lifetime. And any assets that are already in the trust avoid probate, right? So that's a major thing to consider when you are doing your estate planning, because we want to avoid all the legal costs, the time spent with the court intervention, the money spent on lawyers for something that you already own. So having a well-drafted trust is extremely crucial. And then if you have children with disabilities, right, you can also have special needs trusts. You can have, there are two types of special needs trust. You have a first party special needs trust and a third party special needs trust. Usually the special needs trusts that are done in conjunction with the revocable living trust is the third party, because the third party does not have a Medicaid payback provision, and it allows for you to leave your assets to that special needs trust for the benefit of your child. The first party special needs trust does have a Medicaid payback provision, which means when when the person with a disability passes, eventually Medicaid has to be paid back. And a first party special needs trust is only done when there is an inheritance or a settlement coming to the name or the hands of the person with a disability. So special needs trusts are crucial when we are planning for our loved ones who receive government benefits, because whatever assets are left in these trusts are not going to be affected, are not going to affect their SSI eligibility or Medicaid. So that's extremely crucial and something to think about. So the revocable living trust that I mentioned is a powerful, powerful tool, because not only does it avoid probate, and saves a lot of headache and burdens and money on the back end when you pass. In this document, you can add a special needs trust for your children. And it's crucial if you have more than one child, right? You are the key holder of how this document is created. So if you have two children, you leave it in the name of these two children. If you have three children and one of them has a disability who receives government benefits, then you leave the revocable trust in the name of your two children, with a special needs trust provision in the name of your child who receives government benefits. So trusts are, like I said, powerful documents that allow you to name a trustee to manage that money for when you are no longer here. Then the other document that's also important, and it's the one that I hear the most, and these are wills, right? There's a huge difference between living wills and a last will and testament. And we're going to discuss each of them as well, so that you know which one means what exactly. So the last will and testament is your basic will. And this is a written document that states who is going to receive your property, who is going to serve as the personal representative of your estate, and who's going to be the guardian of your minor children. So you're probably thinking, well, why do I need a will if I also have a trust? Or why can I just get one and not the other? Like I said, while these two legal documents have different functions, they complement one another, right? And an example would be, in the trust, you have your home, you have retirement accounts. And once you created that trust, fast forward 5, 10, 20 years later, you acquired more assets. right? You opened more savings account. You bought another property and forgot to update your trust. Having a will also done in conjunction with a trust, it protects those assets that you forgot to include or to amend in your trust. So both of these work with one another. And a will also, what it does is that it has a portion where you can designate who is going to be the guardian of your children if they are minors. And if you have little kids now, this is something important because this document, it does go through probate, right? So it only takes effect after you die. It goes through probate. So you want to make sure that if you have minor children or dependents, you include a clause that says these are the people that I'm granting authority to take care of my minor or dependent children when I'm no longer here. And that's important because then it's going to be left up to the state to decide what is going to happen. Another type of document that is also part of the estate plan is a durable power of attorney. And this is probably the most commonly known document because we might all have one. And a durable power of attorney is a written document where you, who is known as the principal, you are granting authority to somebody else, right? That person is the agent. You are delegating authority to bind you and make decisions on your behalf. So could be regarding legal or financial matters. If you want somebody to have the authority to pay your bills, to manage your bank accounts, to buy or sell property on your behalf. There are different types of powers of attorneys in the state of Florida. You have limited, you have general, and you have durable. Durable power of attorneys are the ones that we typically include in our estate planning documents because a durable power of attorney ensures that it continues even after you become incapacitated or you are adjudicated incapacitated by the court. And that is extremely important because it means you are already pre-planning for guardianship, right? Like I said earlier, eventually we all are going to get older. We're going to lose the ability to make quick and informed decisions. And especially for those elderly who have Alzheimer's or dementia or any other types of disabilities that prevent them from making decisions, the court is going to ask, is there a guardianship? But if you have a well-drafted, durable power of attorney that you created when you had that legal capacity, that is going to take place of a guardianship in the future. So, like I said, sometimes us parents, we forget to take care of ourselves since we're always thinking about our children. So if you are in the process of doing guardianship or guardian advocacy or other alternative for your child with a disability, also ask about a durable power of attorney for you. Ask about all of these other documents for you because a durable power of attorney is going to assist the person who you appoint as the agent later on to act on your behalf and make those decisions for you. Aside from the durable power of attorney, you have advanced directives. Advanced directives are living wills and healthcare designation surrogates. So a few slides before I mentioned that sometimes there's a misconception as to a living will and a last will and testament, or a living will versus a will. A living will only deals with medical treatment and end of life care, right? So if you are already pre-planning on how you would like your family members or your loved ones to handle any life support, any resuscitation, any ventilators, any life-sustaining treatments, that is what's going to be in the living will, right? And these documents are important because we want to relieve our loved ones with the burden of making that decision when you are already in a healthcare crisis. So a living will is another type of document that is included in the estate planning aspect. And then besides that one, there's also the healthcare surrogate designation. This one is very similar to a power of attorney, except it deals only with medical treatment and care. And in the state of Florida, you have the option of selecting whether you want this document to take effect when you become incapacitated or to take effect now when, so that both you and your surrogate can act in conjunction or together. Other documents that are part of the advanced directives, and this is depending on the individual, could be HIPAA releases, right? If you have a HIPAA release for the agent or a family member that you will feel comfortable in contacting your doctors and requesting your medical documents and your medical information, HIPAA releases are also very important. They're not always included in the estate planning, and again, that's just case by case basis. Letters of intent. Perhaps you haven't heard of this term before, or if you have, a letter of intent is not legally binding, right? So there is no statute in the state of Florida that talks about a letter of intent, but it is a very invaluable document because here is where you can include personal, medical, and very care and details about your child. You can include their preferences, you can include their routines. And if you have a child with a disability, this document is important because you can include the times that they take their medication, their routine, specifically if they have disabilities that are very focused on routine, you can write out their routine, right? And as they get older, that routine changes, but you can continue amending this document. So this document is very, very important because you can lay out whatever personal details you have about your children. If they have severe dislikes or likes of things in particular, you can put it in this document so that the person who you select as a potential guardian in the future can always refer back and be well informed. So if they have particular doctors, if they have specific place that they go to, specific diet, if they have restrictions or sensitivities regarding particular food, this letter of intent is something that then you will manage and you can amend it as your child becomes older. There's also a pre-need guardian document, a pre-need guardian designation. And this is where you can legally designate somebody in advance to take care of you if you become incapacitated, or a clause in the will for your minor child, right? So for instance, we talked about how the durable power of attorney takes the place of a guardianship, right? So that it avoids your loved ones from going to the court system, involving the court for a guardianship. But let's say for whatever reason, your agent at that time is having trouble executing something that is not included in the power of attorney because never in a million years did you think that event was going to happen, right? So if it's not in the power of it, in the durable power of attorney, then your agent doesn't have the authority to do so. So then if they need to do a guardianship, if you already have a document, a pre-need guardian document, you can go ahead and designate this person, and they will be the one to file the guardianship on your behalf.
Hey, Talia, we do have a couple questions in the chat that are relating to durable power of attorney.
Sure.
Wonder if you could address those. Can you see them or do we need to read them?
I don't see them.
Okay, so one is, does the durable power of attorney take effect the day it is signed, or can it just be held until the person becomes incapacitated? And do you have to revoke a POA if you want to change the info on it?
The answer to the first question, right? If it takes effect when it's signed. So if you have capacity, if you are of sound mind when you do that durable power of attorney, the person who is your agent, right, who has the authority to bind you or make decisions for you, their actions or their decisions are not going to overpower yours, right? So if there's a durable power of attorney right now and you have legal capacity to make decisions for yourself, they cannot trump what you want to do, right? That is going to take more in effect when you become incapacitated. But it is part of the estate planning because you want to create these documents when you are of sound mind. But if there's a difference of opinion and you are still a very capable adult of making your own decisions, that agent cannot take precedent of your decisions.
What about as it pertains to medical surrogacy?
The medical surrogacy, it's the same. So there is actually a template that the state of Florida included in their statute. So it's Florida Statute Chapter 765. And they included what they think is an appropriate healthcare surrogate. And it gives you the choice of, do you want this document to take effect now? Or do you want this document to take effect when you are incapacitated? You can select both, you can select one. It's your choice at the end of the day. But again, I want to reiterate that if you are an adult of sound mind who can make decisions for yourself, someone cannot step in and take over that or remove that from you.
Okay, and then we have one regarding if you have guardianship, should you still obtain a durable POA to ensure the standby on the guardianship paper has an easier time?
So with this one, the reason why you have a guardianship in the first place is because the person is unable to manage their affairs, right? So if there's a guardianship, it means that 3 medical professionals already assessed you or evaluated you or your child with a disability, and they determined that A, B, C, D decisions cannot be made by you. So if there's a durable power of attorney as well, then they contradict one another, especially if you do it after the guardianship is created. Because in the guardianship, you are adjudicated incapacitated by law. So if you are adjudicated incapacitated by law, then you do not have the capacity to enter in a durable power of attorney. My answer to that changes if the durable power of attorney was created way before the guardianship was opened.
Got it. Okay.
And I think I missed the third question on the first one. I think there were 3 questions in one.
No, there was only 2 in that first one.
Okay, and I answered both?
Yes, I believe so.
Okay, wonderful. Now, last but not least, the other types of documents, at least that we include in our estate planning, are deeds. Because if you own your home or if you have homestead on your home, or even if it's mortgage property, you are the current owner. So you are the person who has the ability, the right to transfer that, right? So in our firms, we explain warranty deed, we explain quitclaim deed, and then enhanced life estate deed. This one is Lady Bird deed. It's usually the most commonly known term. And Lady Bird deeds are usually the ones that are done often when you are doing your estate planning, because a Lady Bird deed gives you the authority to do anything you want with your property while you are alive. So you can sell it, you can mortgage it, you can do whatever you want with your property, right? So this one is pretty crucial if you own a home in the state of Florida and you want it to be part of your estate.
Okay, so now we have two more questions. This goes back to the guardianship and the obtainable durable POA. And Deborah says, suppose it is just guardianship advocacy, the POA answer is still no.
So in a guardian advocacy, the person is not deemed incapacitated, right? So for this one, we would have to see what are the rights delegated in a guardian advocacy order. If the right to enter into contracts or the right to sign documents, what was removed and delegated in a guardian advocacy? If the power of attorney is for a specific event, then perhaps it could still be done, but both of them cannot contradict one another. And the reason why I say that is because in a durable power of attorney, the person retains full control of their decisions. Whereas in a guardian advocacy and guardianship, particular rights are removed and delegated to somebody else. So that is actually what I see very often with parents whose children are 18 and the school system in a transition IEP meeting tells them, hey, they're about to turn 18, get a guardianship or a power of attorney. So then parents quickly go to a bank or print out from Office Depot a standard power of attorney, when in reality their child didn't understand that document. They don't know the nature and the consequences of that document, and they just sign it, right? And then they decide to do a guardian advocacy. When you do a guardian advocacy or even a guardianship, that's because any other less restrictive alternative, which is, a topic for another day, is not doable because of the level of independence or the level of support that your child has. So if your child needs little support or has more autonomy in making decisions, then perhaps just do a durable power of attorney or a supported decision-making agreement. But if they are unable to make their decisions, then that's where you resort to more restrictive alternatives like guardian advocacy or guardianship. Both a durable power of attorney and a guardian advocacy can work together, but they cannot overlap.
Okay, so I know you've got just a couple other slides, and we still have some questions on the power of attorney. Do you want to open it up and answer
Yeah,
questions, or do you want to finish?
I honestly, I think the next slides were just about special needs planning,
Okay.
and then it was our contact information.
Okay, so I know Mercedes and Jennifer have some questions on the power of attorney. If you want to unmute and ask your question, or I can read it. I want to make sure that we're answering all the questions that you have. And I don't see them unmuting. Okay, so one question, with a third-party trust, will the government benefits for a disabled individual be affected?
What was the question?
With a third-party trust, will government benefits for a disabled individual be affected?
So if it's properly drafted, if the special needs trust is properly drafted, the main objective of having one is to avoid government benefits being affected, right? So, for instance, if you own a home and you want to leave that home for your child with a disability in the future to remain in that home, we always tell parents never leave it in the name of your child, right? Because when you pass, that is going to be an asset that's going to affect them for SSI eligibility because it's more than $2,000. So if you own a home and you want to leave that asset to your children and they have a disability, you leave it in the name of the trust so that once they retain possession of that, it does not affect their SSI or any government benefits.
Okay. What about if you have a full estate plan, including a will, special need trust, power of attorney from another state, but will be moving to Florida? Do you need to update the documents?
Yes, especially because powers of attorneys, designation, healthcare surrogate, that is state law. So it varies. It would have to, I would still consult with an attorney in regards to that because there might be things that are not valid in Florida and you want to make sure that remains valid. So you may not have to amend anything, but at least make sure that you consult with an attorney so that they can advise you properly to make sure that it is consistent with Florida law.
Okay, and here's one on the power of attorney. If you change the info on a power of attorney, can you write another and have it supersede the previous one, or do you have to revoke the original one?
I think that was part of the first question that I didn't answer.
Okay.
And you would have to do another power of attorney saying, I revoke the power of attorney dated such and such date executed by me. And now this is my original current power of attorney. Um, because the name of the agents may change. If you want to add a successor agent to take over, if that agent is not available when that time comes, you want to make sure that it's always up to date.
Is there a specific form for a supported decision agreement?
So Disability Rights Florida did a phenomenal job when it came to supported decision-making agreements. They may have a template on their website, but the template that they have is just a standard one, right? Each individual with a disability has different needs. Some may have more needs than other. So if you want that supported decision making from Disability Rights Florida, you can use it as a template. We do supported decision making agreement on our firm, but there are, nonprofits that it have the template from Disability Rights Florida. Just make sure that it's always what the young adult wants.
Okay. Is the Ladybird deed the one where the property is granted to the trust?
So the Lady Bird deed, eventually the beneficiary of the property is going to be the name of the trust. So that your property, when you pass, it doesn't go through probate. It just remains in the name of the trust. And during your lifetime, you have the authority to sell it, to remortgage it, to transfer it, to do whatever you want.
Okay, so I think I covered all the questions in the chat. We can open it up. If there's something else, someone has a question up, feel free to unmute and ask.
And just I'll finish with the rest of the slides, which are not many. But I wanted to slightly touch on the special needs planning part. And like I said, estate planning, at least for the parent, it's crucial because you get to be the key holder of how you want your assets to be distributed as to how much percentage you want to go to the special needs trust of your child with a disability. And the reason why we create these documents, especially the special needs trust, is to not jeopardize their eligibility or their future eligibility for government benefits, right? For SSI, for Medicaid. And that's important, especially because we know that the I-budget waiver, you have to be Medicaid eligible, right? And if you're not Medicaid eligible, then you may not qualify for the I-budget waiver. So when you are thinking about, well, what's going to happen when I'm not here? We have all of these assets. We want it to be properly named and distributed. Special needs trust and special needs planning is crucial because although you're not thinking about it right now, it's going to affect them later on. And that's what we are trying to avoid. Um, and I believe that is it. Of course, the disclaimer that it's not legal advice, that it's just purely educational and informational, because everybody's situation is different, right? One family may need a guardianship, another family may need a durable power of attorney. So it all depends on the facts of the family. And this is our information, how to get in touch with us. Like I said, we offer a variety of services, but always keep in mind that is for individuals with disability. So even if it's not a legal issue, we can connect you with community partners, with community resources in whatever county you are in to assist you. And follow us on our social media, on Instagram, where we are constantly posting educational information about APD services, the appeal service, why you need an estate plan, the different types of documents that make up an estate plan, a lot of information about guardianship, guardian advocacy, restoration of rights. But other than that, I mean, I want to thank all the parents who asked questions, Dina, for inviting me here to talk about estate planning, and for you guys for asking very important questions that I know a lot of us ask but are afraid to put it on the chat.
So we will be putting this on our YouTube channel for people to share, hopefully by the end of the week, and we will send out a copy of the presentation to all attendees as well. Oh, we have one more question. Does the decision agreement have to be done with an attorney?
The supported decision agreement does not have to be done with an attorney, just like the durable power of attorney does not need to be done with an attorney, but it's always advisable to have it done with an attorney to make sure that it complies with Florida law, that it is valid, because in order to execute a supported decision-making agreement, your child needs to understand what that is, right? They need to make that conscious decision that I want this person to be my supporter. I don't need somebody to make decisions for me. I just want them to support me. And to have the signatures and the notary and the witnesses to make sure that it is a legal document that can be recognized everywhere in Florida.
Great. Okay, so okay. Well, I think that's all the questions. If no one has any more, okay, let's see. How does the Lady Bird deed and others work if you have a lien on your home?
Well, the Lady Bird deed is not going to take effect until you pass, right? So you remain in control of your property while you are alive. So when you die, it's going to remain in the trust, and it's going to be safe from creditors. So you always want to make sure that whatever deed you are doing during your estate plan, that you include what debts you have, what liens you have, because all of that is going to be crucial for when the attorney or the legal staff is planning your estate plan.
Great. Well, we certainly appreciate you taking the time to give some valuable information. Definitely the more you know, the better it is. So again, we will share this information and put it on our YouTube channel. So thanks to Talia for coming on.
It's my pleasure. Thank you, everybody.